Mr. Venkatramani, the current Attorney General for India. It is truly an honor to have you here with us today, sir. I would also like to extend my warm welcome to Mrs. Vijaya Lakshmi, Senior Advocate of the Supreme Court of India. It is with great pleasure I welcome Dr. M. D. Sham, the President of Rashtriya Shikshana Samiti Trust, and Mrs. Sham. I am delighted to welcome our Vice Chancellor, Dr. Y. Samurthy, Registrar Dr. Sahana Gowda, Deans of all schools, faculty members, and students. A very warm welcome to all of you. I request Dr. M. P. Sham, President RSST, to kindly welcome our guest, Mr. R. Venkatramani, with sampling. Thank you, sir. To begin with, I would like to request Dr. Y. Samurthy to give his opening remarks.
Good afternoon. I want to extend a warm welcome to Mr. R. Venkatramani, Attorney General for India, and Mrs. Venkatramani, and also the President of the Trust, Dr. Shyam and Mrs. Shyam, and all the faculty members and students. We are really privileged to have today with us Mr. Venkatramani. He's holding a very high constitutional position as the #1 law officer in the Government of India, and as the Chief Legal Advisor. He deals with some of the most complex and intractable legal issues facing the country. He advises the Government of India and also the President also on matters that have been referred to him by the Honorable President of India. So we are really privileged to have you with us today. I came to know that Bharatiya Vidya Bhavan was hosting Dr. Munshi Memorial Lecture today, and he has accepted the invite for the today. And I took that opportunity to say that you are coming to Bangalore, and please visit our university as well and deliver a talk. And he accepted my request, and we're truly grateful to you, sir. My association with Mr. Venkatramani is about more than 25 years old, but I just want to reflect on that. I used to work with Justice M.N. Venkatramani, former Chief Justice of India, and he was very fond of both Mr. and Mrs. Venkatramani. And at that time, Human Rights Commission was handling many important matters. One of them was cremation of unidentified dead bodies in Punjab as in height of terrorism. And Mr. Venkatramani assisted the commission in that matter. And again, it was a very complex matter where 2,000 bodies were killed by security forces, cremated as unidentified dead bodies, and it involved a lot of human rights questions, including adjudication of compensation, etc. Later on, I moved to OP Jindal Global University as a faculty member, and Mr. Venkatramani came for many important conferences organized by the Jindal University. I have had the benefit of listening to his views on many important matters, and during the conferences organized by the Jindal Global Law School. One of my students, Ms. Neelam Singh, after finishing her 3-year LLB, happened to work under him as a junior after, and she told me about the the kind of experience she gained while working with them, and the warmth with which they guided, both of them guided her. And so I have many such memories, and it was, in fact, there was Shekatapuram Shankaracharya visited Delhi, and as a Chaturmasha he was there for a month at his home, and it was, I was living close by, and he told me about that visit, and I went and met the Shankaracharya. And it's about a month back, again I got an invitation from Mr. Venkatramani about 70th birthday celebrations of Mr. Venkatramani at near Sringeri. And the previous evening, we had the Center for Visual and Performing Arts function at Trust Office. Till then, the next morning at 5 a.m., I traveled to Sheketapuram to witness 70th birthday celebrations of both of them. And Mr. Venkatramani is not only what you call senior advocate, he's truly an academic, a scholar, and author, and a man of many parts. And a few days back, he received an honorary doctorate at Bharat owned by Rich University. And it's not what you call. I used to see him about a few decades back with a huge tome called International Human Rights, Context, Politics, Morals by Henry Steiner. So he was, and I could at once see, the kind of what you call passion with which he pursued his own academic and research interests. He was associated with all the national law schools of the country, and he had been guiding them, and also the National Judicial Academy. And we are really fortunate to have him with us at our campus today, and we are really looking forward to hearing him on the matters involving Constitution of India. And this morning, his talk was on citizenship. It was new dimensions of Indian citizenship, and he talked about the how the basic structure of a nation is that of a citizen, and he talked about sustainable development. He talked about dharma. He talked about many aspects of citizenship, and it was really extraordinary experience listening to him this morning. And, thank you.
Thank you, sir, for sharing those cherishable memories. Now I would like to invite Dr. M.P. Shyam to give his remarks.
Good afternoon, everyone. Respected Shri Venkatramani and Mrs. Venkatramani, we deem it an honor to have both of you in our midst at the RE University. We thank you so much, personally on behalf of the Rashtriya Shikshana Samiti Trust, for taking time off today and to address our students and our faculty members. I just want to share a few notes about the trust. This trust was founded by the late Shivananda Sharma, who was a high school headmaster in the year 1940, 84 years ago. He thought when the British leave this country, how are young Indians, the future generations, how are they going to be educated? So he met up with a few businessmen of those years and said, we should set up a trust to educate children. With about 4 children, they started in a small room, teaching these children, different moral values, spiritual values, and education. The trust from where it started today, 84 years from then, from one institution, it has grown into 22 institutions. We have more than 21,000 plus students and still growing. We have, right from yesterday, we had the privilege and honor of celebrating 70 years of the Army Teachers College, the Army Teachers Training Institute, 60 years of the Army Girls School, and 50 years for the NMK College for Women. More than 1.3 lakh girls have passed out from these institutions in the last 70 years. Yeah. Some of them have become very successful business leaders, bureaucrats, and leaders in their own field all over the world. This trust is a not-for-profit trust, and it has followed the highest rules of governance in the last 84 years. Many institutions fail. Why? Because governance is not there and they don't have certain vision and principles. But this trust has made sure that the vision of the founding fathers as well as governance is at the highest. The trust believes in imparting very high quality education at an affordable price to young India. In this view, in the year 2019, we started the RE University. We had the founding Vice Chancellor, Dr. Y.S.R. Murthy, we have Dr. Sahana Gowda as the registrar. It started with about 4 schools, now we've added the law school, and the next year we're looking at starting a school on new media and cinematography. We're building a new campus, about 1.5 million square feet, just next to this university building. With these few words, sir, once again, on behalf of the Rashtriya Shiksha Samiti Trust, we extend a very warm welcome to you and Madam, and we are honored to have you. And like Dr. Y.S.R. Murthy said, you are the number one law officer of this country. So, students and faculty, I think we are very lucky to have you amidst us, sir. Thank you, sir.
Thank you, sir, for those valuable words. We are grateful for having the opportunity to host our chief guest, Mr. R. Venkatramani. Mr. R. Venkatramani was enrolled as an advocate in July 1977 and has completed 42 years of practice in the Supreme Court of India. He was designated as a senior advocate by the Supreme Court in 1997. His practice areas include constitutional law, arbitration law, and corporate and securities law. He has represented several state governments, universities, central and state public sector undertakings, both before the Supreme Court and various high courts. He has been actively involved in academic activities since 1988, commencing from his association with the National Law School of India University, Bengaluru, and is also engaged with several law schools in their academic activities. He is a member of Academic Council of Vishwabharati Shantiniketan, member of the Board of Studies of School and Law of Bennett University, and an adjunct faculty of the Jindal Global University. He is a resource person at the National Jindal Academy. Mr. Venkatramani was a member of the Law Commission of India in 2010 and again in 2013. He has served in as law member in the expert group of welfare legislation set up by the Planning Commission, member of the subcommittee on directive principles of state policy constituted by Justice M.N. Venkatacharya Commission for reviewing the working of the Indian Constitution, member of the expert group to examine the structure and functions of an Equal Opportunity Commission constituted by the Government of India, member of the Supreme Court Legal Aid Committee. Mr. Venkatramani has authored several books including the volume on Dodds and Halsbury's Law of India published by Butterworth and on Supreme Court Practice and Procedure. He was appointed as Attorney General for India on 28 September 2022. He has been recently conferred with an honorary degree Doctor of Law by the Maharaja Surajmal Bridge University, Rajasthan. Without further ado, I would like to invite Mr. Venkatramani to enlighten us with his words. Sir, the floor is all yours.
Thank you so much. It's a great pleasure always to be in educational institutions. And Professor Murthy, besides our long association with him, is one of those persons whose invitation is very difficult to resist. And so when he said, please come over to our university, and the only persuasion was to meet with the students and of any pursuit of any discipline, law, engineering, medicine, and to inhale, because I think it's important for a person to be a responsible citizen and moving into high positions, to be able to inhale as much air of education as possible. So I've come here to inhale the education air, which RV University can probably will not mind sharing with me. So that's the only reason I'm here today afternoon. So while Professor Murthy had asked me, give me some choices of subjects to speak. And I found them probably subjects which could be addressed more to a law school student, a law faculty. But I thought, why should I talk only about law? Then he said, I give the choice of the subject to you, but I don't propose to talk on any doctrinaire, approach to subject. I thought we look at contemporary India after independence, And we have an important development amongst called the Constitution. So that's like the first cry of a mother after a child is born, the child cry. The mother's relation, is beyond description. So our country, celebrate the birth of independence, a new nation, and the advent of a constitution like that. Many of us could go back to 1947 to 1950 and visualize the country's great joy in celebrating the advent of a constitution and an independent nation. It will be a very exhilarating chapter for many of us are post 1940, 1950 children, and then I am a post 1947 child. But I would like to visualize that. Because one reason is that to be in a free country means that every one of us are our own agents, our own masters. And with being an agent and a master comes a huge responsibility. If you are ruled by somebody else, you are told, dictated anything about your life by somebody else. But when you are not ruled by somebody else, then everything about your life is what we need to do. So I thought, let me speak about the struggles of the Constitution through education. Did I have an idea when I talked about the choice of the subject? I did not have the least idea what I would like to speak. So, but since yesterday, I began thinking on the subject, and then what is that I really wanted to share in a few minutes of my interaction with you here. Now, if you look at the early period of the Supreme Court as the constitutional head of our country, between 1950 to 1960, who went to the Supreme Court of India to have their fundamental rights enforced? Apart from those zamindars who challenged a wide range of land, legislation, apart from them, you will find the most ordinary and very humbly educated persons who went to the Supreme Court, the High Court, for enforcement of their fundamental rights. So somebody who was affected by a prohibition law in Bombay, an ordinary middle class or lower middle class person, who was given to taking a few cups of cups in the evening. Prohibition law in Bombay was a big issue. He was no great elite or belonging to the upper echelon of the society. Then there was this woman who was driven into flesh trade by reason of poverty, and when a new law was enacted prohibiting flesh trade, etc. So she went to the Allahabad High Court and said, "Look at what you are doing with my life." So then some other person who was a butcher and regulating, butchering and all those kind of things. So you find the most ordinary persons of the Indian society went to the courts for enforcement of their rights. And the Supreme Court doesn't. So I don't propose to talk about their names and details, etc., but this is how it happened. What do you talk about it? The Supreme Court, as a custodian of the rights of the people, began to look at not who came to the court, but what issues came to the court. Therefore, whether attaining a certain level of status or things like that, and it did not matter at all. Now we have some provisions in the Indian Constitution which talk about right to equality, then non-discrimination, and so on and so forth. So, in the early part, again, the 1950s, the question was, how do you distribute equality among citizens of the country in the pursuit of education? Because after all, you go back to the 1950s, the seed of education was vastly different from what it is today. Today, we are fortunate enough, the student community is fortunate to see a vast sea of educational institutions across the country. And like the great poet Subramania Bharati during the pre-independence period, he said, "I would like to see a day when every street corner has a school or a college." So it happened today. And so go back to 50, probably you have 5 or 10 engineering colleges in the entire country. a few medical colleges which are government-run medical colleges in the entire country. And again, government-run school or college of liberal arts or some private institutions. So given that, how do you really distribute equality of access among citizens regardless of caste or place of birth, residence, so on and so forth? And after all, you have a small cake, and how do you distribute the cake among all? And this question confronted the court for a long period of time. It confronts the court even today. It's a very difficult question to be answered for more than one reason. But the court began to engage itself. And then what could have probably enabled the court to find a more equitable solution? Again, I don't want to get into the details of it. So by the time we come to the mid-80s and 90s, slowly, even before the liberalization era in our country, so we saw a lot of private initiatives, colleges began to come slowly, and the onset of economic liberalization was being seen, and you see therefore an emergence of large number of philanthropic minded people and charitable institutions getting into the field of education. So comes at some point of time, the court is now asked to give some answers to questions which are not easily answered. And what are they? First one I said, how do you really distribute equally and equitably the availability of educational resources? But the answer is open up more universities, open up more colleges, institutions, then the answer comes so easily. But that answer is involved again lots of what's called resource investments, quality investments, and an investment of a different order where the claim for equality will be answered again on a more qualitative basis, not mere number but quality. So in the midst of all these challenges, when the Supreme Court began to reach a point of on education, it said education is a fundamental right. So if education becomes a fundamental right, has it provided a wholesome answer to all the questions which confront equal distribution, non-discrimination, etc. So in an entirely different context, Supreme Court said yes, it from a case of Andhra Pradesh, right to education is a fundamental right. Having said that, then who will fulfill the right to education? Do we require, again, private initiatives? We can leave it to private initiatives, or we require a government engagement? Do we require a legal framework? All these questions began to confront the court over a period of time once the court embarked on right to, hoist its flag of right to education being a fundamental right. So we have the next chapter where, before I come to that, somewhere in the 1990s, we have the emergence of large number of private institutions in the field of medicine and engineering. So the court was confronted with one important question: what's the cost of education? Who will bear the cost of education? Private hands, parents, students, or public institutions? And so if they say education becomes a sale and purchase, so what about capitation issues? So these issues began to confront the court again. So why I talk about a series of questions is, on the one hand, we would probably have the government and executive or parliament to the assemblies give all kinds of answers to the questions. But the story would not have ended there. The story would not have ended there because again we needed engagement of people and resources. Engagement of people and resources again on an equitable basis and without a profit making motive. When how do you really realize all of that? So on the one hand, the executive getting into it, on the other hand, the need for some kind of a regulatory mechanism, regulatory framework. So when we had the early stages of a capitation fee agitation debates in the country, the Supreme Court said, well, look here, there can't be any capitation dimension in education, and it must be free from this kind of what's called exploiting the need of the community for having access to education. So came a judgment from Supreme Court in '93, no to capitation. But it sounded very revolutionary, and those pro-education, minded people thought that the Supreme Court had later opened a new chapter on access to education. But as revolutionary and radical it seemed to be, it did not probably answer many unanswered questions. Well, capitation, no, but who will bring capital? And then and today, even today, look at the global level, the cost of higher education. And the cost of higher education is to be borne by whom, and then in what manner, into what extent. And this question is not merely a question Indian education is facing, but as I said, a global issue. But I don't propose to go into that. So by the time the court talked about all this, and right to education being a fundamental right, and no capitation, then came a situation when how do we really encourage people to get involved as managers of education, as those who provide the resources towards education? How do you get it encouraged? What is the incentive? And so is it to be again like a state-funded, completely state-funded, or a state-regulated? If so, what regulations? All of us know that today these questions have certain set of answers which are still debated, certain answers which are not very clear. And but what is important for our purposes? As I said, I didn't propose to talk about too much about law, but since I am in the presence of a very leading educational institution, I thought we can share some of these ideas and see where in the course of educational institutions such as RD University is in a position to offer a wide ranging, availability subjects and discipline, ideas, and how to really merge the supply and the demand question. So the supply and demand away from here, economists engage. Of course, that's again a question whether economists, lawyers, judges, parliamentarians can sit together and find an answer. Well, perhaps that's one way of looking at it. But it's also important that the relevance of the nexus between the education we offer and the education I receive must ultimately be something which fulfills so important needs of a human being. One, I must, at the end of the day, maybe after 35, 30 years of receiving my education in any field, and after having pursued an employment over a certain period, I must feel that I am fulfilled. Well, yes, I've reached somewhere. I'm happy with my education, the fruits of my education. I've been able to pull out something out of what I've learned from my education and made it part of not only my fulfillment, then number two, as part of a community pursuit of collective excellence. So if there are two twin objectives of education, my own fulfillment, and then be happy. If we don't feel happy with what I read and know, the education has no relevance. Today there are problems in the younger generation, the choice of the courses of education they would like to pursue. For example, if you look at the legal education field, maybe in our generation, we just went to some government law colleges or private law colleges, and not because we thought that there is a great incentive of becoming a lawyer or a litigator, but I didn't find a medical course or an engineering course or some other course of great excitement not available to me. I walk into a law college 3 years, okay, fair enough. I get a degree and walk into a court and then work with a lawyer. And after a couple of years, I begin to earn some money. I'm happy, no problem at all. But that's not what's happening today. So the pursuit of legal education over 3 or 4 decades ago was of an entirely different scene, like the pursuit of even liberal arts, those years and what's happening today. So in the legal education enter a great figure called Professor N.R. Madhav Menon, whose idea of revolutionizing legal education with a 5-year integrated law course and setting up law schools of eminence and excellence. So the legal education field has undergone a radical change. So today, young talented minds would like to pursue law as a great employment opportunity and a career opportunity. And I find, enormous talented young students coming into law schools and pursuing law. But again, why I want to talk about the legal education field is so why it has certainly radically altered the contours of legal education and the percentage of women coming into legal education. And it's a very important thing. So in every field today it's happening. The gender discrimination is slowly disappearing, not because you need to fight and shout against gender discrimination. It's happening by reason of several factors. But of course, there is the assertion and the need to affirm that gender discrimination must disappear. Of course, we need to continue to affirm and assert. But beyond that, for a number of reasons naturally happening, discrimination is slowly disappearing. So also discrimination based on caste is slowly disappearing. That I think the important reason is the law has made it possible in one direction for people to be managers of education and to be providing resources of education. But at the same time, law has also imposed enormous burdens on those who become managers of education. So that's where I find after Supreme Court talked about capitation fees and fundamental right, the right to education, the fundamental right, today the framework of education is vastly different. Constitution says right to education is a fundamental right. We have a new law on right to education. And that is radically again altered the education at the school and the school levels. But the question still to be asked is, well, access to education has been made, altered, changed, and by the court's intervention. And whether access to education being made available is the final answer, is the final key to equality. The answer may not be so. So probably we need to travel still more roads to be travel, and where I think the experience of higher education institutions in our country, which is very different from certain other parts of the world. If you look at probably the educational graph in UK in the past 200-300 years, or you go to a country like the United States of America, just to digress here for a few seconds. So America has an entirely different, socio-political complexion. And some people try to compare the racial dimension in America with the caste issue in India. I would probably like to disagree to some extent with that. So the American complexity based on color and race continue to play, I would say, the public mind of USA till the 1950s. So notwithstanding the great champion Abraham Lincoln, he gave the great Gettysburg Address. Many of you should read what he said. And till 1954, the US mind was still grappling with the issue of racial discrimination. At some point of time, the US Supreme Court said, well, we're all equal, but we are separate. So equal but separate was a great doctrine which divided people on race. But somewhere in 1954, for good reason, the US Supreme Court said, no, everybody is equal, no equal but separate. So but 1954, this declaration of the US Supreme Court did not really mean abolition of racial segregation. It took another 30, 40 years before the actual racial segregation matters of admission into education institutions in the US would come to an end. You walk into some of the very leading universities in the US, which probably claim to say that racial segregation has come to an end, but it's being disputed. So why you want to talk about it is the discrimination on the basis of any factor obtaining in the society is something an anathema to equality. So how do you deal with discrimination? So whether it's based on status, wealth, or any other background, any factor which discriminates between human beings, artificially, socially created by us, must go. And what will it make go? I think education and education, moral education alone will make it go. And that's what Swami Vivekananda said, that's what our great Dr. Radhakrishnan, great exponent on education in India. So all of them thought on these lines. So So on the one hand, therefore, we have a role played by Supreme Court of India in opening up the field of education for a more and more involvement of both people who would like to provide education and access to education on the one hand. On the other hand, we still need to answer the question, how do we really ensure that there is no discrimination, number one. And number two, the access to education will be on an equality basis. And number three, the resources for accessing education. How do we really make it again non-discriminatory? These are questions we need to have engagement of economists, public policy thinkers, educationists, and managers of education, and certainly, of course, lawyers and judges. Not as problem creators, as problem solution, givers. So I think people like me, when I look at the role of lawyers and judges, of course, the ordinary consumption of lawyer is that you aid a litigation, you got a divided approach to solutions. You have an adversarial legal system and both parties fight, and lawyers make the best use of both parties fighting and make their fortunes. But I suppose only one part of the story. There are, in the legal professions, play a very important role in articulating these ideas. That's why I said in the early days, very ordinary people, humble ordinary went to the Supreme Court, who made it possible for articulating the ideas. The legal profession thought education, a lack of education, is no reason for people to get their rights enforced. If that was a genius of the legal profession in the early days, I think it has continued to play an important role in articulating some of those ideas. And I should say, when the Supreme Court of India, somewhere in 1993 and later in 2003, the right to know is a fundamental right. All of us would like to be free citizens. We would like to know as much as I would like to know, whatever I would like to know. But I'm liking to know whatever I would like to know. What do I do? I live in a democratic Republican society, and I have a choice of a representative who go and sit in the assembly and will make laws for good governance for our country, so that my freedom is intact. My right, therefore, the right to know ultimately means one, I want to know what good things are good for me, and secondly, who would I choose to be my representative in the assembly, the parliament. Supreme Court said your right to know is a fundamental right. And it did not, there's no provision in the Constitution says a right to know is a fundamental right. It said so because the freedom of expression is a fundamental right. How do I express myself freely if I do not know what I need to know? So if you are a candidate with a criminal antecedent and I do not know about that, I'm not actually exercising my free choice of selecting you. Therefore, the right to know is now a fundamental fabric of a democratic society. And that was made possible by the Supreme Court giving the declaration. And in the right to know, educational institutions play the most important role. And they say right to know again, whatever one needs to know, whether I would like to, I remember two things. John Adams was the President of the United States say back in 1700. And I often used to quote this. It's a very interesting quote. He says, my children I would like them to read, today I read War and Peace, right? I would like my children to read architecture, poetry, and philosophy. I would like my grandchildren to read the tapestry, right? And things like that. That means what? As we move in a society where war was the only way of living, and you need to study war. But they move away from a war in a society where you are less war-prone, then you will be studying something else. And more you move to a society where peace prevails, you will only study tapestry, philosophy, architecture. So in a similar vein, Marx wrote in one of his treatises, then he said, in a communist society, I would work in the forenoon, fish in the afternoon, and read Shakespeare in the evening, right? So that means the availability of leisure for each and every one of us. And the availability of leisure means what do I really learn? And how do I make this learning possible that the leisure I have on my hands ultimately would be a soul comforting leisure. So these are a role which an education can make available to any human being. So what do I need to know? The ultimate question is, I come to a college, I come to an institution, I look at those who teach me, but the ultimate takeoff is one, what is given to me, and what I do pick up. So it is not merely a unilateral, linear process. So the right to know is not merely what a teacher gives you, it's what you also pick up. What you want to pick up. How much inclination you show in picking up. So every moment students spend in an education institution, I think is a time well spent, and it's like laying a foundation for the rest of your life. And I personally believe, before I conclude, the teacher who taught me, Professor Madhav Menon, was a great teacher in legal education. And I happened to be one of his best students, which took me to Supreme Court practice. I had worked with him for long in the law school education field, and I always, whenever I lecture, speak, talk in law school or anywhere, I said one great tradition of our country is the Guru Shishya tradition. The teacher is one of the most revered person in our country. And that reverence is not merely because he is giving you knowledge. The teacher is an embodiment of a personification of a transmission of knowledge, wisdom, values, and all the combined things that a human being can give you. While today the machine can give you all that. Well, the machine cannot teach you values. Your internet cannot be a value addition machine. So I would probably very humbly, whether I should the word appeal, or probably reach out to each one of the students to say that this Guru Shishya tradition, which our country has grown, nourished, I think is an important tradition. It's a tradition in the sense of a value which enriches your own self-fulfillment, you can say that. I've experienced it, and I think I would like to share this kind of experience with every student wherever I go. And finally, today morning when I spoke about the subject about citizenship and emerging trends, for each one of us, as a student or the one who teaches or the heads of institutions, in a globalized world today, there are challenges which are more visible, there are other challenges that are invisible. Now, while we are a free country, in one sense, our economic policies, our political choices, our relationship with the international community, and the wide range of issues are not determined freely and exclusively by, let's say, our democratic component. Our country may be under exertions and pulls and pressures of a wide range because of the global situation today. And how do we really raise ourselves to ensure that as a nation we are in a position to meet these challenges and enrich our nation. When I say enrich our nation, I'm again not talking in a parochial way, where my nation is great, Pakistan is no, Bangladesh is not. I'm not talking in that sense. I'm talking about enriching a nation in the sense preserve the values which our nation has so far given to us and share those values with the rest of the world. Because sharing this value with the rest of the world is important. So that's how, students of history would have known, we call the Silk Route, trade route from China to Europe to Asia to Rome. That Silk Route is a different Silk Route we have today. So probably there are more than one Silk Route today. So how do we really become active participants in enriching values important for our own country and for the rest of humanity? Thank you for your attention.
Thank you, sir, for those very insightful and thought-provoking words. So, with your permission, the room is now open for question and answers.
Thank you, sir, for the great speech. In a recent interview with the leaflet, I saw that sir had talked about how India should try to move away from the adversarial system of justice and without completely abandoning it. But sir mentioned that we should try to move as far away from it as possible. I'm not an expert in law, but I tried to read about it, but I didn't understand like all of the points that sir brought up. So if possible, could sir elaborate a little on that?
It's referring to recent. So we should move away from that recent.
I know. But what would be your question? Your observation is one thing. What's the question?
As in most countries have just most countries do not have a hybrid of inquisitorial or adversarial systems, right, sir? So I just want, but sir mentioned that we should try to move away from adversarial, the system, without completely abandoning it. So I wanted to know how that would play out, sir.
The way adversarial systems were designed earlier, they are no longer adversarial in one sense. And if you look at the division between the civil law system and the common law system, the difference is only in terms of the procedure, right? If you go to England or USA, still you have a jury system as part of the adversarial system. We abandoned the jury system for good. Right? There's a lot of debate on that. But in the absence of an adversarial system, I'm not really talking about an ordinary courts in our country, whether that's at different levels, the civil court or a criminal court. We talk about adversarial system at the highest level, Supreme Court. Right? You pick up Plato's Republic, the Socratic dialogues. The Socratic dialogues are the most fascinating dialogue one can ever read. And actually what happens in an adversarial system is just some element of Socratic dialogue between two competing minds. So two competing minds talking about different dimensions of the same issue and asking an umpire called a judge to pick up some kind of a connecting thread. So this is the beauty of an adversarial system. But so in a classroom, the teacher addresses the students. Suppose we are in a mathematics class. There is no need for a debate on whether an equation can be written this way or the other way, except a very more insightful student than the teacher can stand up and say, oh, this equation can be even thought about differently. That kind of a debate is very different, right? So you stand in a classroom where science is being taught, as compared to a classroom where law is being taught. The difference will be very, very obvious, right? Because you pick up any law or any statement about what ought to be done, what ought not to be done. Law is ultimately about what ought to be done and what ought not to be done. Right? We are not talking what is good and what is bad. When law says something ought to be done, it is good, right? So good and bad may come into this law, may not come into the law. If we think good and bad comes into the law, that's a different issue. Therefore, in a science class and the class teaching law, conceptually they're different. So therefore there is a more than one possible view on what is good and what is not good, despite the law being there, then the most suitable system to decide what is good and what is not good must be again a replica of the same kind of a debate. Now, two persons sharing their views on what is good and what is not good. But everything need not proceed in these lines. A small family dispute somewhere. Brother and sister fighting, father and son fighting. You don't need to have an adversarial system. You just need a mediation system. You just need a conciliation system. So large sections of our community now do not need an adversarial system at all. They just need a conciliation or a mediation system. We had in the Industrial Disputes Act a process called conciliation and mediation, which really does not work, right? For a different reason does not work. So we need to design systems which will serve the justice needs of different sections of our community, which need not be necessarily adversarial, and where it can be confined to a narrow area, where the reason of debate alone the best of an idea emerges as that idea which must be accepted as good for common good. That's very interesting to see.
Good afternoon, sir. You spoke about the right to education in your speech. So, my question was that the present position of law is that the right to primary education is a fundamental right, but higher education is still not. So, sir, in your opinion, have we reached a stage now where even higher education could be made a fundamental right? Do we have the resources, in your opinion, to do that?
The need for a law to say something is a right will arise when the need will not be otherwise ordinarily realized or fulfilled. And the need to talk about primary education being a fundamental right arises because we still have a large section of our population for whom primary education is still not fully realized. And it will be realized in a qualitative sense. Therefore, bringing in a law, making it a fundamental right, means the competence of parents, the obligation of parents, and a societal duty to ensure that this right is realized, is out, that's how it is. When it comes to higher education, we have very complex field. The choice which students would like to take and which field of education I would like to go. Because there is no informed choice, many students do not really make informed choices. But the moment you make it a fundamental right, then the choice, making up a choice, and the heavy burdens which education institution will have to bear in dealing with the claim of fundamental right can bring it more chaotic than what it is today. So I would probably prefer that a little longer, and for good reasons. It should remain free from that. And the better way of going over it is to ensure that more and more people come in to offer their resources and their time and towards provision of education. And if you allow this little free play in the joints, then that should be a better solution. Because I've seen after the capitation fee era, almost for about 3 to 4 months every year, the Supreme Court is full of education cases. 3 to 4 months, right? So maybe that's why lawyers make good fortune. That's a different issue. But I don't see very often cases to be resolved by a conciliatory, mediatory approach, kept remaining in court for a long period of time, and anxiety of the students, and the concern of parents, and equally the institutions. So all of us spend a lot of money in education. I would probably still feel that higher education being brought in the fundamental right should be avoided.
Yes, so thank you for the speech, sir. So my question is, in the last year or so, artificial intelligence has been developing at a very fast rate. And do you think that in the coming future it can be integrated with our legal system? And if so, how do you think it would affect the legal system?
I don't find any difficulty in this integration at all. We have some vague notions about artificial intelligence. It is only a tool. Like the internet is a tool. These are all tools which we have, created, invented, and discovered for ourselves. The best way of utilizing, exploiting these tools, I think there should no difficulty at all. We have some vague fears about artificial intelligence and then overtaking human intelligence. I don't think we need to worry about it. I don't think that day will ever come. It can never happen like that. Because the human brain is far more naturally wired and far more brilliant than any system which humans can create. Whatever we create will be subject to other laws, but what we are subject to vaster natural law, which none of us ever know. So I don't think there's any problem there. But teaching methods, teaching methodology, using these tools, well, yes, artificial intelligence can be used. So if you have to travel a long distance and be in a laboratory, all that can be done by a wide range of technological devices. And the knowledge transmission can be handled again through intelligence, artificial intelligence. But for me personally, again, they're only tools. The manager, the one who handles the tool, is a teacher. And if the teacher is in charge of the tool, well, great.
Good morning, sir. Sir, so elections are on the way and they're pretty nearby. And according to statistics, there's not enough urban and youth population voting. So why is it that voting has not been made as a fundamental duty, and why is it not compulsory to vote? And won't it be ensuring democracy if voting becomes compulsory?
Well, what do you understand about enforcing a duty?
It's just like
I was be in my classroom at 10 o'clock. Right? If you don't be in a classroom at 10 o'clock, you can be marked absent. If you regularly, absent, then you are not allowed to take the examination. So there is a system which works, right, on its own. Can I say it's your duty to attend class at 10 o'clock and I will enforce the duty against you? It is being enforced in this way. So some duties are enforceable. Certain duties are really not enforceable. In the sense, then I had to have policemen in every street corner would go to every home and pick up people in the morning and say, go and vote. Right? That's possible. If you have enough number of policemen to do that. But if after taking them to the poll booth, now can the policeman ask them to make a choice? Why do people not go to vote? Because they're not making choices about voting. That means either they're not here or they don't want to vote. So that the question of physical presence in voting is only one aspect of the matter. The inclination of mind to be part of democracy is the most important part of the matter. How do you really enforce the duty? It can be enforced by more and more confidence in democracy, right? By removing all those negative features which we face today, like people with criminal antecedents entering into politics and becoming legislative assembly members or ministers or whatever it is. So the distrust which you place on the democratic system and the electoral system, the reasons for the distrust are removed. You don't need a duty enforcement mechanism at all. You will be happy to vote because you are willing to choose your representative and you know who you are like to elect. You have a good number of people there, right? So that's what this is the way you can handle it, not through a duty enforcement law and things like that. So if you have a teacher who commands your respect, right? You will be in the classroom 10 minutes ahead of the timetable, right? That's what it is. So attraction.
Thank you for addressing all the questions, sir. I'm sure we all have enough insights to carry. Now, I would request Dr.
Yeah.
Sir, I would like to ask about due process of law. Initially, in the initial draft of the Indian Constitution, they used the term due process of law. But in the final draft, after due deliberation, they consciously made the choice not to use the term due process of law, particularly in Article 21. So, I want to ask, how do you see what would have been its impact on unfolding of the fundamental rights in India particularly life and liberty? And secondly, what could be the reason for deleting the term due process of law? Whether the makers of the Indian Constitution at that time were apprehensive about the court, or maybe they were not very were not ready to trust the court, that all the power will ultimately go into the hands of the court. So better not to use the term due process of law in the Constitution itself.
This is a very absorbing question for a good law student and and the classroom devoted to law. But regardless of the fact that many of you may not have any connection with law or legal education, as a matter of information, this due process of law is an American constitution coinage. And just by way of some illustration, the fourth Chief Justice of the Supreme Court of the United States, Chief Justice John Marshall, was in one of his famous cases, Marbury versus Madison, which is treated as a great treatise on constitutional law. He said it is the province of the court to declare what law is, the department of law is. And then who will declare what law is? So the due process of law in the US Constitution became the fertile ground for the Supreme Court of India to say, Supreme Court of the United States, to say what is due process, what is due under a process. So much so when the Indian Constitution was being debated, just one of the judges of the US Supreme Court, Justice Frankfurter, is said to have given advice, B.N. Rao, who was in the drafting committee, not have a due process clause in the Indian Constitution, saying that we had enough in our country on uncertainties. And but very indirectly, somewhere in 1978, when Supreme Court of India was dealing with Maneka Gandhi's passport issue, he said all state action means law, executive action, policies, governmental decisions must be just, fair and reasonable. That distinction was reached by Supreme Court as a departure from an earlier view taken in 1950s when A.K. Gopalan, Marxist leader, was detained under the Defense of India rules. So the question before the Supreme Court was that, here is a law which authorizes somebody to be detained without a trial, and therefore the detention does not violate our Article 21 of the Constitution, which says no person shall be deprived of our right to liberty, without procedure established by law. Supreme Court said, here is the procedure, that's good enough. So, but that view was departed from in Maneka Gandhi's case, and both said, it is not enough to have a law, we must have a law. Every law must be fair, just, and reasonable. That is due process. So Supreme Court brought in due process by its pronouncement. And today, there are two schools of thought. And whether Supreme Court is a final arbiter of everything in our country, or elected parliaments and executive governments are the final say. So you have law ministers making statements about Supreme Court, governments making statements about Supreme Court, all about due process. Right? So maybe you and I have some thoughts on due process.
So why don't
So it is like a certain field for people to play around.
We take a couple of more questions.
So I want to ask, as you quite rightly pointed out, gone far ahead and quote unquote your words for Professor another one was revolutionary. I'm wondering, given your long experience, what do you see as the infirmities that we still have in legal education?
Legal
Uniformities
Informative.
in the legal education.
in legal education.
What do you think we should improve further?
I don't think there's any infirmities at all. In legal education, or for that matter, any field of education, I'll just come to the distinction a little later. In legal education, the idea was to prepare people to be equipped to go and practice as litigators in a court. And that was a narrow idea of legal education. And then it begged the question, who would go to court for solving what kind of problems? And who all can go to court? And if we need to move away from that and to give an answer to the question, what are the justice needs of different sections of a community? What are the justice needs? Who needs what kind of justice? Assuming that our country will continue to be an unequal society for a long time to come. Although the inequalities generate our justice needs. If I belong to a particular social strata, my need for justice is different. If you belong to a different strata, your need for justice is different. Therefore, the movement away from mere equipment of a person as a litigator in a court to unraveling the dimensions of a just social order, generating a just social order, an egalitarian social order in terms of the constitution. Legal education was also marched correspondingly with this kind of a need. Therefore, when it tries to do that, there will be shortcomings. Because the moment you move from one regime to another regime, the transition will always be one of shortcoming. It is not because it's like a high jump, right? From a short jump, a high jump to a long jump, all those shortcomings will be there. So I don't see any infirmities. But as things stand today with the legal education, 5-year law school, every state having a law school, national law school, and mushrooming private legal education institution where quality is absent. So the question is, how do we ensure that there is a level playing field? That everyone who undertakes to provide legal education must provide it at the same qualitative level as any other field of education. Right? You can't provide an engineering or a medical education. We need a certain qualitative level. So as much as you provide quality in other fields, so much you provide in the field of legal education. If that resolve is there, I think that there's no question of infirmity. We have problems in admissions and things like that. I think that's a very minor problem. That is like an occasional, when the weather changes, we have problems of adjustment with weather. The body, it's just like that. I don't think it's a very serious problem.
I have a question. There's a debate going on in the government and the judiciary on selection of judges. See, judiciary uses the collegiate method, and the government says, you should be delegated. For an evolving nation like India, for a young nation like India, what do you think would be best suited? Because in the bureaucratic system, you have the IAS, IPS, IRS, they write an entrance exam, pass it through, and then they go into the training schools, and then they become a career bureaucrat, policeman, or income tax official. So, something like that good for the judicial system, or what are your thoughts on this? You've been in the judiciary handling your matters for the last.
There's no political sensitivity in this area. All that you see as political sensitivity is a media created issue. Sometimes, of course, government feels very strongly about it. But I think it's a socially sensitive issue. The sense that if you want somebody who is equipped, intellectually well equipped, morally equipped, and in terms of integrity, without doubt, we want those people to be sitting as judges. Now, who are they? Do they wear everything on their forehead? There's no way of identifying all these qualities in a human being. So the way of knowing these and identifying is a problematic. Whether it is a law minister does it or a collegium does it. And when both of them do it, there could be party conscience. I may pick up my own people. I may pick up people of own ideologies or a political, belief or faith. So it comes to a collegium, it cannot be an ideology. It could be your man, my man, ego. Or if somebody had to read the insights on the number of the persons who become judges in the High Court or the Supreme Court, to find somebody writes about 100 to 120 families in India whose daughters, sons, and nephews, nieces, so they are the judges in High Court and Supreme Court. Why could it happen? So on the one hand, we want diversity. People belong to any section of people, community to become judges. So how do you really make it happen is the most important question. And power to determine it should not ultimately be with either the government or the collegium. There must be a kind of a very informed, interaction. We are in the process of trying to do that, and I think it's going to take a little more time before that can be reached. But those of us in the community will talk about collegium. You see all in Twitter or this or that. You only receive part information, selective information. You start writing, reflecting on that. So much of the information which flows into the public domain about what collegium does or what government will do is a selectively made available information. So if I know 100 facts, my reflection will be different. If I know only 10 facts, my reflection will be different. That's how social reflection on this is affected by facts which are really not fully known. So India will surely move towards a reasonably acceptable understanding on this, judges and the government. But the most important question is there are a lot of other issues within the judicial system. Like if I want to be a judge after 25, 30 years of sitting as a judge, I would like to have a comfortable life. And I become a judge at the age of 40 or 45 in the High Court, my family should be taken care of. The cost of education, talking about it. So who will buy their education? If I paid only about 2 lakhs in a month, then how do you buy their education? So these are the material concerns of a person when you become a judge. So if I earn 30, 40 lakhs in a month, why would I become a judge? So these are problems. It's both collegium and the government is trying to look at. But more important is that whether I earn 30 or 40 lakhs, if I think that I must do a service to the nation, I will give up and become a judge. It's a call of the mind. It can happen. And so the most important question is how do you really identify them? And how do you really incentivize people to sacrifice a little, to renounce the good part of life and become, in a way, renunciates sitting on the bench 12 hours a day. And many of us do not know that the Indian Supreme Court and the judges of the Supreme Court of India are the most hard-working judges in any part of the world. The US Supreme Court, let us say, works on 100 cases in a year. The Indian Supreme Court works on 10,000 cases in a year. Right? So morning to evening you have to listen, and then you have to then find out after you listen to cases which need to be further listened to, then you have to deliver judgments. That means a lot of reflection, reading, and when do they do that? So the evening hours, the late night hours. So the whole day virtually spent by a Supreme Court judge on doing justice. So many of us think that the Supreme Court judges have a lot of facilities and this and that. And well, what are they doing? That's the wrong question to be asked. Wrong question to be asked. They sacrifice.
Two questions.
So for children with disabilities, I believe that right to inclusive and accessible education is more relevant than the general right to education. lack of accessibility is itself a discrimination issue. But Article 15 of our Constitution does not provide for an explicit protection against discrimination to these children with disabilities. United Nations has also recommended India to amend its laws and amend Article 15 and provide for this explicit protection. What do you think? I want to just gather your insight in this matter from a litigation point of view. Do you think this inclusion will be helpful for children with disabilities in terms of realizing their rights more effectively?
No, ultimately everything depends on how you would like to apportion the resources. So these are constitutional guidelines, are some kind of a roadmap. So in that roadmap, sometimes you may have to lay a new road. Sometimes you go on the road already laid. When you lay a new road, you still find out the laying of a new road in a social transformation is a very complex issue. So I would think it should demand more of a socio-political economic approach than merely a constitutional approach. Sometimes constitutional approaches become mere rhetoric, political rhetoric. So election time they become more of a rhetoric. That's a problem. So you enter into freebies, another issue. So education cannot be a freebie issue. And ultimately, all of us, each one of us, must strive to secure what you need to get. The moment you think you should be given certain things without your striving, without any effort, then I think even if you get it, what you do with what you get will not ultimately make any value to you. You may get it, you may use it, but you will really not get the best worth of what you get. So the striving part of it, that any student is equally important. Of course, there is certain systemic differences there. When it comes to gender, there are certain systemic issues. But many of these are slowly disappearing. And if you have a two-pronged approach on management of resources on one hand, and using a constitutional tool also to facilitate distribution. That's how we should work.
Last question, Nadu.
First of all, at the onset, thank you for a delightful talk. It was really enlightening. My question is with respect to the enforcement of rights. We have seen that Supreme Court in its quest for the enforcement of rights, which also includes education for that matter, has embarked on judicial adventurism beyond the confines of judicial activism. This is without realizing or without watching the state capacity. So how do we seek a balance that the Supreme Court do not venture out and open and go into the judicial adventurism zone instead of staying within the judicial activism? So how do we seek a balance there that the state interests are also managed along with the enforcement of rights?
When you ask this kind of questions, right? I just to nothing offensive. Let me very lighter. I remember standing up and asking a question to a very renowned advocate general from Madras when I was a student. I thought nothing to do with this question. Don't mistake me. I just want to say something. Yes. So the advocate general is a well-known advocate general. He said, you stand up again and reflect on the words and the expressions you use in your question. You go back, like, in a film, you reel back on it and then kind of play back. You know what's really happened. I didn't understand the question which came back to me from the application then. But much later I realized, I went into the profession, that every word we choose or an expression we choose for any communication, very often we take many words and expressions has granted with a certain meaning and a connotation. Like if I am the minister, I will say Lakshman Rekha. Right? Supreme Court is crossing Lakshman Rekha. Lakshman Rekha, yes, good. Everybody understands Lakshman Rekha. But why do you say that? Because something which you don't agree with is happening inside the court. This is not happening in India alone. The question as to whether the superior courts of every country are expanding into domains beyond what the constitution says their jurisdiction is a global phenomenon. And why it's happening? There are any number of reasons why it's happening. But ultimately, what is the meaning of right to life? Right? So when I am detained beyond 24 hours in a jail with policemen beating me all around, so whether it's my life or liberty, who will answer that question? Somebody who is not involved in that activity of beating, that person is extremely qualified, right, to answer that question. So there are several such questions which happen day in and day out in the daily life of a country. And to answer them, it is not probably the domain of the lawmaker. Once the parliament has enacted a law, the parliament goes into silence. Right? The law is handed over into the hands of the government. You look at the departments of government, how much of thinking about law it happens during executive process. They also think. So in their thinking, there are problems. So you have a problem about my thinking as the head of a department, and then you say, no, your thinking is wrong. So therefore, somebody else will now sit in judgment over whether my thinking is wrong or your claim is right. It has to go to the court. So in this process, there could be cases or occasions when the Supreme Court can also commit an error, right? Go overboard. But as many people deeply involved in deliberating on court's role in determining what law is finally, there is a lot of debate around the globe. Maybe we need to have political theory where somebody will say this is the role of the court. But I don't know whether that will answer the question finally. As I look at the courts happening every day, you sit just one full day in the Supreme Court or the High Court. Wide range of cases are heard by bench of 2 or 3 judges. I sit and watch it and then try to gather what's really happening in the court. What really happens in the court is after a law or a policy or a decision is taken, the final meaning of how the law, what the law is, the final solution of how the law can be executed and enforced is a very complex process. The lawmakers may have one whole vision, but when it comes to enforcement, it has to go through a whole set of activities, thinking, deliberations, and like that. So there's a very complex process that happens. Even at this point of time, I sit in the court and watch cases which are being argued in council, and I try to look at what's really happening in the court. Why is the court doing this? It's a fascinating thing that happens in the Supreme Court. Why ultimately? Because we want to have a free country where every one of us have the consolation and the comfort that nobody has taken away what is due to me. That is an important feeling. That feeling can come in only that the court is doing what it needs to do. In the process, of course, as I said, that will be a little overboard by the court. And that's where Lakshman Rekha come in, and it must come in. And if it does not come in, perhaps a judge can become a despot. So between being a despot and transgressing certain lines and not transgressing the certain lines, I think that's how ultimately democracy and things like that work. Well, that's a very interesting thing. Go to communist China.
again, thank you so much, sir, for facilitating such an interactive session. Now I would request Dr. N.P. Sham, President RSST, and Vice Chancellor Dr. Y. Samurthy to felicitate our guest by presenting him with a moment. Thank you, sir.
See, I would have failed in my duty if I had not said anything about Mrs. Venkatramani.
No,
And,
please. Please, please.
so everybody says that, look here, somebody is always behind you. No, 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 no. We together in our life, and I'm happy to be together. And, our tradition, our country, we talk about a lot of sexual discrimination and backwardness, etc. I think a wise management of life by both partners is a solution. I've come to believe a lot of legislations which need to address concerns of gender are very important. But there are some problems with some of that. In my 2 terms as a member of the Law Commission in addition to look into many of the legislation, I found that we need to go beyond certain models of legislation when it comes to gender equality, gender discrimination, gender concerns. How do we go about it? Suppose I say something about Bharatiya traditions, and somebody will say the Attorney General is Hindu to a man, right? And if I say, well, I belong to, I don't names in US and Europe, was very radical feminist thinkers whom I read very closely. And you go to the extent of saying anything, any thought, any idea which is a social product, right? Either male dominated, male driven social product. And for everything as a social idea which exists today must be rejected. So then there is a void. These are very extreme positions being taken all over the world. So we need to be a little more balanced, and then that can come only by understanding life from an angle where tolerance, love, compassion, care, and all that should enter your daily life. I find a lot of people in the younger generation. When I say younger generation, today it's 18 to 40, correct? We have all the problems. People come with broken hearts and broken minds and broken lives, right? So maybe some other day when we address law students, we can talk about.
Thank you, sir, for those wise words. I would now request Mrs. Shah, Dr. Sahna Nada, and Mrs. Sham to felicitate Mrs. Vijay Lakshmi,
No,
Senior Advocate, Supreme Court.
not necessarily, I've done that.
You are basically quite the same. And I heard you describe you as the chief legal editor.
You always.
Thank you for doing the honors, man. As we come to a close, I would like to thank our guest for the evening, Mr. R. Venkatramani, Attorney General for India, for graciously accepting our invitation to join us today. We feel extremely privileged to hear from you today, sir. I would also like to extend my gratitude to Mrs. Vijaya Lakshmi, Senior Advocate of Supreme Court of India, for being here with us today. I would also like to take this opportunity to thank Dr. M.P. Shyam, President RSST, and Mrs. Shyam for being here. Thank you, ma'am. Thank you, sir. And of course, my kind regards to our Vice Chancellor, Dr. Y. Murthy, for his constant support and guidance. I also thank the Registrar, Dr. Sandha Karna, for his due presence today. I thank all the deans from all schools, teaching, non-teaching staff, and my dear friends for your time and presence. Thank you all, and I hope you all have a wonderful evening. I request you to please join us for the refreshments outside the venue. Our volunteers will guide you.
Very good MC.